Every prosecutor fear. 100,000 strong. We can't disappear. 100,000 eyes watching every gear. Watch the machine. Watch it. Watch the machine. Watch it. Daddy drew the blueprints on delivering the scene. 100,000 deep. And we just getting 200 on the horizon, 500 on the map. Million in our future, every video we tap. We the watchdog they feared. Dad, you called this years ago. You said the system needed witnesses, and now the witnesses on show. Every prosecutor in America gotta hold the line. Every defense attorney watching, we the spotlight on design. Pro say the foundation, you process the religion. 100,000 classrooms learning how to win the decision. This ain't a channel, this a movement at this point. Every comment is a teacher, every video a joint that cracks the system open, lets the people see the truth. We the machine, they fear that. We keeping every proof. 100,000 deep. Let's go. The machine is here. 100,000.
All right, everybody, welcome, and we are here today to discuss and break down and react to the George Pino verdict. So first of all, if you're unfamiliar with the George Pino case, this is a case out of Florida, Miami, Florida. A very rich real estate developer went out over Labor Day weekend and unfortunately had a unfortunate boating accident that resulted in the death of a young girl. Very controversial because when the officials arrive on the scene, and again, it's looked at as the officials doing favors for a wealthy, rich guy who's influential in the Miami area. They don't field sobriety test them. They don't really do a proper investigation like probably every other citizen would get. Certainly a citizen at an auto accident would get. And they essentially take his word for what he drank and conclude that alcohol had nothing to do with this accident. And he's essentially charged with misdemeanor boating with death charges that would result in 60 days in jail. He ultimately, the Miami Herald uncovers his case and gets into it, starts investigating it, and they discover, of course, that there's a lot more to this, at least on as it looks, than what might be, at first glance. One of the facts that comes out is there's all these bottles of beer and liquor on the boat that were used, and immediately, of course, this causes outrage because people believe that bolsters the idea that Mr. Pino was drinking and should be facing much more serious charges than what he was. Prosecutor office gets involved. It's now politicized, and they ultimately decide to charge George Pino with vessel homicide and then eventually upgrade the vessel homicide charges to manslaughter. Problem is, they don't really have the evidence to support these charges because at the end of the day, when you look at the investigation that was done and the results of that investigation, there's really nothing there. All that's there is that this gentleman, at least what things appear to support, is that he was an inattentive captain, which is not criminal. It does not rise to the level of manslaughter, does not rise to the level of vessel homicide. Now, from a civil perspective, yes, there's liability to be had, and he is absolutely held accountable in civil court to the tune of around $18 million that he pays out personally to settle all the cases and hold himself accountable. But ultimately, he's on trial facing 30 years in prison, and they get the two bulldog prosecutors in the courtroom, one of which is clearly someone who prides herself in thinking she could win any case regardless of whether the evidence supports it. And what you see is a 3-week masterclass in a prosecutor trying to convict somebody without evidence. And it culminates in probably, one of the quickest verdicts we've seen, where the jury just absolutely rejects this prosecutor's position. And there we are. Now, the damage done to Mr. Pino is by having to go through this process is, of course, tremendous. It appears by all accounts, Mr. Pino is a very good man in the sense that he's a nice guy. He's a successful guy. He's not, he's a dad. He's an individual who made a mistake, and they're criminalizing a mistake. And that is exactly what it looks like. Now, whether Mr. Pino had too much to drink or not, it appears by all accounts that's not true. Even the victim's father said he felt comfortable with his daughter being on the boat and did not see signs of impairment. A blood test at the hospital ultimately showed that George Pino's blood alcohol level, whatever it was at 0 by 11 o'clock. The accident happening shortly before 7 p.m. So 4 hours. Clearly not a large enough amount of alcohol for it to stick around for 4 hours. That doesn't mean he didn't have alcohol in his system. But that's what we're left with. And then, of course, now a confused public who watched the trial and think, how did this guy get away with something? And the end result is he didn't get away with anything, because he should have never been charged with what he was charged with. And the prosecuting attorney's office giving in to a politicized effort and public outrage this time doesn't get away with it in Florida. And they put their top dog prosecutor on, who gets now publicly embarrassed. And there are some of you who saw this case for what it was, and then there are some of you who clicked into the idea that he's charged, there's a death, and he's got to be guilty of something, right? Well, no. And 6 jurors down in Miami looked at this case and got it right. And we're going to go through, and I'm going to try to help you understand exactly what happened here. So I haven't said a lot about the case as it was going on. I said a lot about the case. I mean, I have, if you've been following the website, but I haven't come on and put videos out. If you go on justiceisaprocess.com, I haven't done the final article write-up yet, but there's a wealth of articles. There's a lot of videos. Read the descriptions, okay? Always read the descriptions. Read my community posts. Read my X posts, and you can get a feel for where we're at with this case. And I try to go down the middle with these cases. You know, I try to be fair. But the reality of the situation is George Pino should have never been charged and in the position that he was in this case. Now, that does not mean I'm discrediting the devastation that the victim's family, because there were 2 victims in this case. There's one victim, one young lady lost her life, the other had her life in unbelievably altered in a way that she will never be able to live without assistance. And that is absolutely a tremendous tragedy. And simply acknowledging the fact that what George Pino was charged with does not line up with the law should not discredit the victims or what they're going through. And I think George Pino himself has absolutely, personally, made sure that he was accountable in many, many ways. Now, the state could have potentially got the original misdemeanor charges that Mr. Pino was charged with. They probably could have got a conviction on that. But because they decided to upgrade the charges, throw those out, George Pino ultimately opted not to allow the jury the option of convicting him of those. And he ultimately did a gamble that many people at the time when he did it during the charge conference were thinking he was insane for. But turns out he wasn't, because turns out the jury took their oath and took their jobs very serious and held the state to its burden. So a proud day for the justice system when that happens. He had an excellent defense team. And yes, it's another example of how the wealthy who can afford good attorneys get the correct outcome, while others in Florida, specifically Florida, end up with the public defenders down there, and they end up with horrible outcomes, outcomes that are definitely not supported by the law. And the prosecutors in this case, I want to be very clear about what I witnessed, and I'm glad the world got to witness it, because what you got to see was the prosecutors felt emboldened to take this case on and felt overconfident in this case because of exactly what I just said. Normally, a defendant would come up against them with a public defender who was weaker than a paper suit, and they'd pour a little water on that paper suit and it would crumble and fall, and they would get their outcome. And it wouldn't matter whether it was justified or not. It would just be, she was a bulldog. You saw her in court, running over everybody, confronting Mr. Pino in court inappropriately, claiming that he was staring at her, okay? acting like she was on the schoolyard. Just an absolutely ridiculous display. Unprofessionals on so many levels. Doing really, in my opinion, distasteful things with the witnesses, going up, treating Mrs. Pino absolutely disrespectfully. And a lot of Florida prosecutors, I noticed that, they will feel emboldened to treat defense witnesses or people that are associated with the defense like they're enemies. And that's the problem that you get when you get prosecutors who really lose track of their job. Because, you know, my wife and I were watching the trial. She said, "Oh, she's just doing her job." I said, "No, she's not." Because, see, that's the misunderstanding people have, is the prosecutor does not represent the victims. The prosecutor actually represents every party in that courtroom. They represent the defendant. They represent the state, the entire state that they're representing, their county, and the victims. And their obligation is to everyone, because their obligation is to file charges that are supported by the facts and the evidence. And so many times we don't get that with prosecutors anymore, because they believe they're here to deliver justice. They're here to convict somebody, and you're not. And I remember my dad was going to run for prosecutor because he wanted to bring that concept to the prosecuting attorney's office. He didn't end up running, but it was something he and I discussed a lot, that in today's age, it's the whole reason behind this channel's name, that justice is a process, not an outcome. And that is should be more reflected at the prosecuting attorney's level than the defense attorney's level, because the defense attorney is there to block prosecutors who get overly aggressive. They're there to help the defendant through their process. So the defense attorney actually is the person who is not there to represent everybody. They're there to represent their client and help that person ask the questions, raise the issues that they need to raise to protect themselves against a state that might be out of control. The prosecutor, on the other hand, has an obligation to all parties, really. They have an obligation to the defendant that when the charges don't support a particular charge, or when it becomes clear that they don't, when they review evidence that the police bring in, they are supposed to adjust the charges to meet what they're supposed to be, to meet what they can support. They are not supposed to go to court and try to get a conviction anyways. They are not supposed to go to court and get creative. They are not supposed to just get emotionally involved and go, somebody died here, so I want someone in prison. They are supposed to sit down and look and say, does what happened in this case match up with 30 years in prison? Is that okay? Does that serve society? Does that serve a purpose? Has a crime been committed here? You're not a good prosecutor if you convict somebody who didn't do something, or you convict somebody for something that's far more elevated than what actually happened, or what you can actually prove. And it's the job of the prosecuting attorney to justify that to the public and go out and say, this is what it is. They are not there to solve crime. The police are there to police crime. The prosecuting attorney is there to ensure that people are being prosecuted for crimes that actually match up to the statutes. And so many of them forget this. But that is why justice is supposed to be a process and not an outcome. And the process is the evaluation of the evidence. And that's why I always find it funny when you get to a trial and a prosecutor stands up and says, we're here to find the truth. No, we're not. No, we're not. That's the biggest lie. That's the biggest lie ever stated in a courtroom. You are there for a trial. What is a trial? A trial, by name, is a trial of the facts. It's a questioning of the facts. So many prosecutors get upset because the defense attorney says, I'm going to ask these questions. I'm going to ask questions of your witness. How else do you try the facts? In a plea bargain, a plea bargain does not allow facts to be tried. It does not allow that trial of facts to occur. So one could even say, hey, should plea bargains even happen? And the answer to that is, in my opinion, no. I think it goes against the nature of the true purpose and fairness of what should be happening in the law or with the law and with a trial and the purpose of a trial. Because the purpose of a trial is to ask questions. And ask questions and ensure that before we are about to lock up an individual, a citizen, a fellow citizen, take away their lives forever, or take away their freedom for, potentially forever in some cases, or for a significant amount of time, remove their ability to make money. We have a trial, and 12 citizens sit down and say, yep, there's no questions, there's no doubt, there's no reasonable doubt. And also, let's talk about that for a minute. How many prosecutors try to twist and turn what a reasonable doubt is? Oh, it's not an elimination of all doubt. No, it's an elimination of all doubt. I mean, it's elimination of all reasonable doubt. So anything else that's left is unreasonable, right? So don't play with that, man. If there's reasonable doubt, why is the prosecutor so afraid of the idea that a reasonable doubt comes up? In fact, you should have been dealing with that already. When a case comes, it shouldn't come with any doubt. There shouldn't be any doubt left. And if there is, well, that should be dealt with. And that should have been dealt with before you ever got to trial. But don't play with what the meaning of reasonable doubt is, because you're not here to win. If there is reasonable doubt, you as a prosecutor should never lose, right? If a not guilty verdict happens, the prosecutor should be standing on the steps with the defense attorney and saying, I thank you. Thank you for raising these questions. This is a fair outcome. And thank you, jurors, for doing this. Thank you for finding the doubt and finding the questions. And go back and and that is from the founder's perspective. The idea was, when the founders put together our court system, they said they would rather 100 guilty men go free than one innocent man get convicted. And we have drifted far away from that principle. Anyways, with that said, I just want to run through with you a little bit of information here to kind of help you understand where things kind of went off the deep end here with this case. So I put this together here, the anatomy of a conviction effort, okay? So in this case, essentially what the question at hand in this case that the prosecutors had to answer when they were bringing this case was, and this is it, felony recklessness versus a tragic accident. The prosecutors attempted to state that felony recklessness was 14 people on board, even though there's nothing that says 14 people couldn't have been on that boat. He was driving 47 miles an hour, even though all of their police experts or witnesses said, yeah, 47 miles an hour is common. In 9 seconds of visual inattention. And then, or tragic accident, which the defense said, it's a clear day, it's a sudden crash, there's no intent to harm, and rule breaking by Florida law, is not a crime. Breaking the rules is not a crime on its own. So it says, does 9 seconds of failing to see a channel marker elevate an accident to a felony, especially when the state cannot mathematically prove impairment? And that was the biggest problem in this case, is the state could not prove impairment. Because as I stated, this was supposed to be an impairment case. And that's what everybody was upset about. And then the impairment could be proven. So the state had 3 pillars. And it was really, a lot of it was distasteful. She stood up in her closing and called him Camp Counselor George, abdicating duty. Essentially saying, this guy, who's a good guy by all accounts, who's out there with his daughter, celebrating her birthday, known as Camp Counselor George, meaning he was known as a good guy. Every parent there trusted him. There was not a parent that was saying and screaming. This would be a totally different case if he just got behind the wheel and took off with everybody's kids and then wrecked into a mile marker and everyone's screaming, my God, George, what are you doing driving with my kid? No, that wasn't what happened here, right? That wasn't what happened here. No, it was Camp Counselor George. He was liked. Then they said that he was abdicating his duty as the captain of the ship. There's a 9-second GPS track that shows he drove in a straight line for 9 seconds. And then afterwards, they wanted to say that his that he lied about a boat that allegedly caused a wake, meaning like a wave that caused him to drift into the marker. The real issue was they wanted to charge him with boating under the influence. They wanted to have the ability to say he was impaired, but they couldn't because guess what? They didn't test him because their investigation didn't allow for it. And they wanted to weaponize the lack of chemical testing by pivoting entirely to a digital certainty and post-crash behavior. In other words, what they wanted the jury to do was to make a leap, was to get so angry by his post behavior and suggest that says, hey, listen, this guy is guilty of something. Convict him of something. So the setup here is, and this is the way she does it. She says, Labor Day weekend, celebrating an 18th birthday, defendant hosts a pickleball tournament. She actually criminalized the pickleball tournament and said that somehow made him an evil guy. Now, the part that obviously is, my opinion, lacking in judgment and should definitely come back and be reviewed in the future for anyone thinking of doing what he was doing. He packs beer, Prosecco, and seltzers for a boat of 14 underage girls. He probably should not have done that. But there was no connection to the drinking to the death. So, again, that was just a fact that didn't look good that they used. And she says he sets the course of the boat. She says the boat is, by her own explanation, overloaded by 1,000 extra pounds at the bow. He's driving 47 miles down the wrong side of the channel, and she presents it as a pickup truck with 12 unrestrained girls in the bed, drives down the wrong side of the road, of a bumpy road, and goes right into a telephone pole. That is her take on this case. Now, that's an accident. Okay, and again, the pickup truck I don't think is even fair in my opinion in this. I think it's a convenient way to discuss it, but I don't think it's completely fair because a pickup truck does not have seating. A pickup truck is not, a back of a pickup truck would not be a recognized safe way to ride. That boat, every girl was in a seat. There was no seat that was said, don't sit there. Every girl on that boat was in a seat. Yes, it's not as safe as a vehicle. Yes, you don't have all the, you don't have all the enclosure and all the pieces that a vehicle might bring to you. But to say it was the back of a pickup truck, I don't think that was a fair analogy. Okay, but that's how this prosecutor's trying to win this case because she doesn't have a case. And I think if you go back and watch her closing argument, she gets all pumped up, and then she literally comes to the point of where she's supposed to argue the real criminal nature of this. And it almost sounds ridiculous when she does. Because she can't get it out because it doesn't make sense because this is not that case. Because the moment when she's supposed to go to the outrageous behavior, he drank 10 beers, he jumped in the car, he jumped in the boat, and he was, showing off and showboating for these young girls. None of that's there. He's a dad driving across the channel. He makes a mistake, and it ends up with a catastrophic consequence. And that's not criminal in the state of Florida. Maybe they want to change the law, and that's what you have to do. But if that at the time this happened, it wasn't the law, that was not enough, well, then it's just not enough. A prosecutor trying to make it enough is not doing her job. So she acknowledges, I can't prove his blood alcohol level, so I didn't charge it. Why is the defense defending against a charge I never filed? The 2 beers admission, reminding the jury of Pino's statement to Lieutenant Thompson, framing it as unquantifiable undercount. Literally saying, look, you should infer that Maybe he has more, or he drank more than what it was. And if you conclude no, that's not what the law says. She doesn't get to just tell the jury, you just get to decide some phantom amount. She's got to prove impairment. She's got to prove that he drank more. She argued that a 17-year-old passenger consumed 10 drinks but sobered up on adrenaline, explaining why officers saw no obvious impairment in Pino later. Perhaps one of the most egregious and ridiculous arguments. In the conclusion, she successfully paints a picture of a boat fueled by alcohol without having to meet the legal burden of a BUI charge. And to me, that was wrong and inappropriate, because what she was trying to do was essentially say to the jury, listen, we failed to prove impairment or how much he drank because we didn't investigate, but we want you to just assume that he was impaired. Assume that he had more than, that he had more to drink than what he told us. And that's not right. That's not how this is supposed to go. And it's not okay that a prosecutor would do that. Someone's death does not allow a prosecutor to abdicate her duty. What you saw, it's funny, she's arguing about the abdication of duty. And yet in this courtroom, she was abdicating her own duty as a prosecutor in looking at a case and acknowledging that she didn't have the evidence to prove it. And it was egregious. And look, there are those of you that said she should be censured or not. I don't know that it'll rise to that level because a grand jury indicted. A judge let the case go through. There are many levels of insulation that says, you know what? There were judges in the courtroom, there were people in the courtroom, and they allow it to happen. But what should be concerning from everyone is seeing what goes on, because what we got to see is just how Florida operates, how a Ty Tucker can end up down in Key West. He's a homeless guy at the time he's arrested. And that's why he ends up in jail multiple times, only because he finds a childhood friend who has money and she gets drained financially fighting the system down in Florida. But there's a problem down in Florida. The prosecutors have lost their way. And because the prosecutors work for the people, it's okay when the people of Florida or anywhere around, because they're also a reflection of our country, and anytime you see a prosecutor out of control, that should be a moment that everybody steps back and says, wait a minute. That's not okay. Because you know what? It could be any one of us that finds our way there, but we may not have millions of dollars to hire the best attorneys. We may not have the resources to put on a defense to the degree that George Pino did. And when you don't, that prosecutor we saw in that courtroom, she will run over every single one of you. And she will lock you up for 30 years. And you will be sitting there going, how did this happen? But she's supposed to be protecting every side of that courtroom. That is her job as state attorney. That is the job of the prosecuting attorney, state attorney, U.S. attorney. They're supposed to look at the facts of a case, and they're supposed to match it up. You are not supposed to get to the point we got to in this case, where I'm sure millions of dollars got wasted. I loved it when prosecutors, not just her, but many prosecutors stand up and go after a defense expert who dares to hire a $35,000 expert. Well, excuse me, how much money did you spend on your expert? How much state money was spent on every police officer investigating this, on every lab analyst that went over to DNA, on every cell mark diagnostic person that went in there? Do we sit there and go, hey, what's your salary? How much are you making? No, because if we put dollar figures to all of that, of course there was money spent. Why is it so offensive that a citizen says, we want to go check that work? We want to get another opinion. Oh, it cost $35,000? Yeah, that is a damn shame, because that actually cost money for the defendant who's defending themselves against state action. In fact, technically, if they're paying taxes and stuff in the state, they're paying for it twice, right? Because who's paying for all the stuff that's investigating you? Now, of course, it's also protecting you at the same time, but the whole point is that shouldn't even be an issue of credibility. The idea that this expert is going to lie, is going to come in, if there's some evidence that this expert's lied before, if there's some character flaw, but the main character flaw that you bring out, which she did against the as she called it, the concierge neurologist. I mean, come on. It's offensive and it's ridiculous. And it just, like I said, everything was on display here. Every terrible, horrible action, dirty, and you know what? It got fully exposed with the not guilty verdict. So anyways, go back here. So the silent witness, basically the witness she started with, the witness she ended with is that he changes a 5 degrees to port. He enters the wrong side of the channel. He's going 47 miles an hour and he strikes the marker. All right? Well, how is that criminal? And the only way you can make it criminal is you have to show beyond a reasonable doubt that when he made the change, he did it in some reckless way. That it wasn't an accident. That it wasn't due to mere inattention. And then she counts out 9 seconds like it's freaking an hour, right? 9 seconds is nothing when you're driving. I sat there and I was like, I wasn't startled by 9 seconds at all. I'm like, okay, 9 seconds when you're driving a boat and you're out there and you're looking at everything, 9 seconds is like not any time at all, especially if you're adjusting stuff and you're doing, and there's, you know, whatever. But a mere inattentive moment is not enough to say, we send you away for 30 years. Remember, the guidelines of this was if he got convicted of both, the state would have been able to argue the guidelines as 20 years. I'm sure she would have argued for 30, and the judge would have probably came in at like 13 years or something like that. Or I think what the judge would have done ultimately would have done 11 if he was convicted of both, because she would have just combined the two together. But 11 years. 11 years for something that, I mean, that this prosecutor was going to be willing to sleep at night, knowing that she did that. So how does it come? We have the phantom boat lie. Defense claims another boat forces Pino out of the channel. The state argues it's a persistent lie told to Lieutenant Thompson, civil lawyers, and entered into civil proceedings to dodge liability. People don't lie about accidents. People absolutely do lie about accidents. What are you talking about? It does not mean that he did something criminal. It means that at a moment, you know, a couple things happen. Either he had a head injury. Can you rule that out? I don't think he could. Or B, he lied because he got scared. Oh, people do that all the time, okay? How many times do you have an innocent person that gets caught up because they lied or they got brought into an interrogation room and they're lying out of nervousness? And then, of course, there's the, hey, he was covering it up. So, but to say beyond a reasonable doubt that because he lied about the phantom boat, that somehow means he was reckless or he was grossly negligent and with you know, giving a complete disregard for human life? Absolutely not. That's ridiculous. The medical expert, Pino suffered from amnesia. Again, like I just came out, the state says a $30,000 concierge fee. Admitted Pino had a perfect 15 Glasgow coma scale the night of the crash and admitted she never actually asked Pino what he remembered. So again, the $30,000. I've already kind of touched on this, but the idea that that's even an issue is stupid, okay? Because how much money is the state paying their experts? And that's a lot of money. These experts might be making 80, 90, 100,000. Some of these places, the state's paying $50,000 to go get stuff reviewed. They have an unlimited budget. So the fact that the state would make issue with a citizen who actually has a budget and says, I'm going to review your stuff, to me, is outrageous on its face. Then we have the environmental excuses. Sun glare, tides, marker 13A. And again, remember, the defense simply need to raise these. The state has to eliminate these beyond a reasonable doubt. She claims they're debunked by the NOAA data. The sun was to the right. The geometric alignment, 13A only blocks 15 from a distance when it's too far to see anyways. Now, the problem with that is these are all things, again, prosecutors love to live in a place where it's just, hey, you know what? It's a perfect world, right? So she says it can only be seen 4 seconds out. That means he had to have seen it. No, it doesn't. That means that when you put a combination of all this in a real world and the fact that, as my son was demonstrating, he was demonstrating this to me the other day where he said, you look and your eyes can't see the middle, right? So when you're out on the boat and you're looking in the real world, yes, if you look at a picture and you go out and you're slowing down a camera, but in the real world, right? Your eyes are locking in. Your mind is locking in. There's a possibility he's looking. He's doing everything he's supposed to be doing, but where he's looking, his mind doesn't register that. And then he looks over here and he looks over. The problem is the state must prove beyond a reasonable doubt that it wasn't an accident. That would be an accident. That would be mere inattention. And they have to prove he did something reckless, that he did something grossly negligent, and with a reckless disregard for human life. And where is that in this case? Where is that in this case? It's not there. The result is she says that stacks itself. That stacks itself, and a jury could find it. And the judge let that go through. It should, again, the judge herself also failed in this case by allowing it to. The defense objected to the standard of negligence and requested folding the misdemeanor definition into the felony instruction. Judge wouldn't allow it. The defense requested providing the jury with 13 case law summaries showing how past courts defined vessel homicide, essentially saying the way the state was trying to define vessel homicide directly contradicts 13 cases, 13 decisions that the jury and the judge says, nope, they're going to decide on the case, and we're going to let them make their jump. And defense requested a special verdict requiring all 6 jurors to agree on which theory of manslaughter occurred, and the judge said, nope. The same thing we've heard in many cases where they say, doesn't matter what theory, as long as they agree on a theory, all 6 of them just have to have a theory. So if 3 think it was one theory and 3 think it was another theory, as long as they're agreeing on a theory, they don't have to be unanimous on the theory itself. So, the judge opened up the channel, so to speak, and said there was a wide way for this jury if the jury was angry and teed up, and the judge did everything she could to try to pave this line and to pave the way for the state to get their conviction. But the jury did their job, and I'm proud of that jury because in a case that needed to have this happen, they did it. Now, what were the paths? What were the 2 paths to getting there for manslaughter? An intentional act. And this was the one that the defense fought the hardest on. The state's position is that Pino intentionally steered the boat and set the speed that caused death. The defense objected to that and said the state admits Pino didn't intend to hit the marker, so how could steering be the proximate intentional act for red rum? The judge's analogy says, like a passenger grabbing a steering wheel, the grab is intentional even if the crash wasn't meant to kill. Except that steering alone should not be. When you're grabbing a steering wheel, that's a reckless act. Steering, making a good faith steering effort should never be that. This judge was so wrong in that, but again, she didn't care. And neither did the prosecutor. Because all they cared about was one thing, was getting a conviction. And they thought they were going to do it. I really believe they did. Culpable negligence, conduct so reckless that it causes death without anyone meaning for it to happen. The judge's refusal to strike path A gave the state the 2. So again, when you apply that standard, what conduct here was so reckless that it caused death? Like what was the conduct that was so far outside the norm? And you can't just say, well, he was behind the boat. Well, he locked it in to not. Okay, but that's not so far outside that a normal person would have thought to themselves, by doing that, death is likely. But I'm going to do it anyways. I'm going to gamble. It's like taking that bet. That's like, you're betting on an underdog. That's, you could win $100,000 for $1, right? Or for $100, and you go, okay, I'm going to place that bet, and then your significant other comes and says, what'd you do with the $100 we needed for the kid's birthday? Well, I put it in an investment. I invested it, and you would say, was that negligent? Well, in that investment, yes, it was. You bet something that you knew you were going to lose it, and then you lost it, and you go, well, I lost it. Could you have thought you lost it? Well, no. I mean, I thought I was going to win $100,000. It was ruined. No, the odds of losing it were so great that you should have known you were going to lose it. You were literally just throwing it away. And that's the path to get to culpable negligence. It's a path that's just, you haven't lost it. There's a chance you won't lose it, but it's so much greater that you're going to lose than you're going to win that you should have known losing was inevitable. So if you do it, you're going to be treated like you intentionally lost it anyways. And that's the best way to understand what reckless conduct so reckless that it causes death. It's a recklessness. And that's called culpable negligence because you're essentially having to take responsibility as if you intentionally did it. Now we're recognizing the fact that you didn't just tear up a $100 bill. You didn't just rip it up. You didn't just burn it up. But you risked it in a way that was pretty much like doing that. And then you lost it. And now you're going to deal with the consequences of it. So you don't get to, your wife doesn't just say, okay, you're walking away from this. Yeah, you made a great investment. It's not like you went and invested in something that said, you were going to have, that nine and a half out of 10 times you're getting a return on your money. And then something catastrophic happens in the market and your money goes away. That would be something that would say, well, should you have been betting birthday money on that? No, but it was still a very safe bet. It doesn't rise to the level. Your wife might say, your ass is going out to work on Monday to get that $100 back. But it's not like you just, it's not treated the same way. It's not the same level of, it's not criminal, right? So, that's what we had in here. Now, the other issue here that the state tried to do here was and the judge did get in the way of this. And that is the navigational rules clause. The judge did hold strong on this and basically said that she instructed that breaking the rules alone, and this is where people got really confused and said, well, he was a captain. He had to follow the rules. He had to have life jackets or this or whatever. No, but that alone itself is not enough. Breaking a navigational rule is not enough. Okay? That is enough to say civilly, he might be held accountable. But that is not enough to say just because you broke a rule, because you didn't have X or you didn't have Y. You have to show that there's got to be more to it than that. There's got to be an egregious way you broke the rule, or that you broke the rule in such a way that it puts everyone's life at risk. And not just simply saying, okay, he drove 48 miles an hour instead of 47, right? If you exceed speed and it's 90 miles an hour, and every person would say, nobody should ever be driving 90 miles an hour down that channel. That's crazy. That's a totally different scenario. But even then, the Florida Supreme Court has said that they're not even certain that speed alone is enough. And the defense gave the example of the case, which I'm familiar with that case, where there was drag racing going on and they hit a woman with a stroller. And the Supreme Court came back and said the speed in that case was not necessarily enough to say that the conviction, to hold the conviction in that case. You need more than that. So now this is what the defense needed to do, and they did. They needed to reclaim the word accident, and he did in his closing. Shrink the 9 seconds, and he did, and neutralize the lies. In other words, prove to the jury that the lies were not willful in the sense that they were not being told because he was trying to cover up a crime. And again, like I said, there was multiple reasons for the lies. And again, the state's job was to prove beyond a reasonable doubt, that those lies, sole reason he was lying was to cover up a crime. So, obviously I was very concerned. I was worried because in Florida, I've seen situations like this. It's a state where you never know. It's very, very law and order oriented. But I was worried, because I felt like the prosecutor felt very emboldened. She felt very comfortable conducting her case the way she did. But the good news was George Pino had a very good defense team with him, and I'm glad that he did, because without that great defense team that he had with him, it could have been a very different outcome for George Pino, and would have been a very different outcome for George Pino. And he did not have anyone in the courtroom from the judge's side, or even or definitely not on the state side, who were trying to ensure fairness for him. He had to bring that. So, anyways, that's my take on this. Let me know your take. I know a lot of people are still trying to digest this verdict, but I want to know. I want to hear from you. So let me know in the comments, of course, what your opinion of this verdict was. Do you believe it was the right verdict? Do you believe it was the wrong verdict, and why? And of course, as always, guys, justice clearly, and this is one of those cases that shows it. It works better when we're watching. It works better when we watch, because this is the type of case that we want to highlight, put out, and show to the world what happens when a prosecutor loses their way. And it's not just her, it's the whole office. There were decisions many levels above who made the decision to roll forward with this prosecution. And they put a prosecutor on this case who they were very much believing was going to deliver the outcome that they wanted, which was guilty verdicts. So with that said, guys, I'll talk to you soon. Remember, justice always works better when we watch. So keep watching.
But the lesson stayed. He fought every demon he had, and he still came back. Down in Martinsburg, the city's getting cold. Dad was on the corner with a story untold. Battle every morning, but he still got out. Helped another stranger, made another route. The bottle was a teacher, but he never won. He poured the coffee, opened up the lotto one, and one became 100 and 100 became more. Even when his body couldn't carry what he bore. And they asked me why he fought so hard. Tell them it was love. And they asked me how he kept the law. Tell them it was love. He was fighting, still fighting demons no one saw. He was teaching, still teaching, even broken on the floor. Now the addictions let him go, and the legacy keeps the flow. Daddy, you can rest at last. I'm carrying the future, not the past. I had my own dark season, knew the heavy chains, inherited the hunger and the fire in the veins. Watched him in the mirror, same eyes looking back. Took me years to figure out which road I had to track. Got to the other side of it, sober and awake. Picked up the camera, picked the doctrine in the wake. Every day I'm winning is another day he wins. Every video I post, that's where the legacy begins. And they ask me why I keep the fight. Tell them it was love. And they ask me how I see the light. Tell them it was love. I was fighting, still fighting demons no one saw. Now I'm teaching, still teaching what he taught me through the door. And the addiction had to fall, 'cause the legacy, I grew it all. Daddy, you can rest at last. I'm carrying the future, not the past. 105,000 strong now. Every one of them a soul that he would have helped somehow. You're not